First case, which I need to put my glasses on. Kesler versus Progressive. One reminder for counsel for the appellants in all the cases, if you wish to reserve up to 5 minutes of rebuttal time, let me know, and I will let you know when you get to that point in your argument. Remember, we are live streaming, so speak into the microphone, please. And with that, Mr. Gunn, we're ready.
Good morning, and may it please the court. Lee Gunn for Bridget Kesler, the petitioner in this interlocutory appeal, seeking that you quash a trial court order that invaded both the work product and attorney-client privileges of the claimant bringing a bad faith action. Briefly and factually, this arises out of a car crash on March 3, 2018. Progressive affords $200,000 in uninsured motorist coverage. 19 months after the loss, Ms. Kesler's counsel below filed a civil remedy notice, thereby triggering the 60-day cure period that statute affords. This being a first-party bad faith case, that case is controlled exclusively by statute. There is no common law right, and never has been in Florida, for someone to bring a bad faith case for first-party misconduct. The CRN simply alleges the 1B1 of 624155, that is, the failure to settle the claim when Progressive could and should do so when acting fairly and honestly and with due regard for Ms. Kesler's interests. Now, it's undisputed that Progressive could have paid a $200,000 policy limit during that 60-day period to cure. It did not do so. Had Progressive chosen to pay during the cure period, it is undisputed that no claim of bad faith would or could exist. It is these facts, Your Honors, that conclusively establish Ms. Kesler's willingness to settle for purposes of meeting the could have settled under the statutory scheme.
One question.
Your Honor.
None of you mentioned in your briefs or petitions, opinions. Did you serve a proposal for settlement from $1,000?
Out of time from when the violation was noticed, yes.
And Progressive when it expired?
Yes.
Under the law, had they accepted it, would you have a right to bad faith?
Yes, you can preserve your bad faith case in a proposal for settlement that only brings the claim, Your Honor. So it's certainly once you, as you know, once you perfect the bad faith right, and here where we had both counts pending in the case, right, we had under the Friedman authority, the court allowed. So if you have the entire action being both bad faith and you can serve a proposal for settlement, the terms of which are directed to only count one, the count, or to the entire case. So you could have served and preserved.
So they took Ms. Catlish's deposition, right?
Yes. And
they asked her about her evaluation. She did talk about tangibles, intangibles, medicals, lost wages, future medicals. They even asked her what she thought it was worth, and she testified that it was worth more than $200,000. But it wasn't until they asked her, was Ms. Kesler willing to settle for less, that she invoked attorney-client privilege. Is there a Florida state case that allows a trial court to compel any attorney, whether it be for Progressive or for a plaintiff, to testify about the oral communications with their client about whether or not to take an offer?
I'm unaware of any such case. Indeed, Genovese would provide support for the proposition that a carrier's counsel is protected from my asking Progressive's lawyers, well, what did you think the case was worth? Did you advise Progressive to go ahead and cure? I can't get into any of their communications under Genovese, which was a clarification of the Ruiz holding, which said that the insurer's file is fair game, but then not so far as to say the attorney-client privilege is also fair game. Genovese said no.
That's her deposition. Would you accept less?
I'm sorry, Your Honor?
They asked Ms. Kesler in her deposition, would you accept less than policy?
I honestly don't know if that's part of the record.
It's not in the record.
Yeah,
it's very sparse.
Right.
Progressive doesn't give us lunch. Just tells us the case is not worth anything, and the other they give the old times, only 3 times medical offer. And when $65,000 to $75,000. But yet argue, she didn't need service, she didn't want service. Nobody wants service. But, so, tell me on what basis, because the trial court ordered an in-camera inspection of the privileged documents, which means under 1.280C4, she can restrict disclosure or not. But yet she granted the second deposition of Ms. Catlett with no guardrails or limitations. It's simply granted it. What was the legal basis for that?
I believe that the court must have conflated the third-party principles of the willingness to settle in order to prove that there could have gotten a release if you would have sought one. All I know is the court on argument of progressive accepted the proposition that because willingness to settle is an issue, then that means they're allowed to get into any willingness to settle at all that was injected in this case, including by injection waiver, the attorney-client privilege. And I agree with the court, and we specifically briefed the fact that the in-camera is not right for us to talk about the documents because it hasn't been. But to the court's point, when you say to the witness, you have to answer all these questions about inferentially what's in these documents. That's why we felt the petition was necessary and appropriate under jurisdictional grounds and practical grounds as well, Your Honors. So,
But it isn't, I mean, I don't want to make your argument for you, but one of the things that strikes me is if a party wants to settle a case, it makes an offer, and the other party either accepts it or rejects it. And Progressive made at least, two offers, if I remember, in this case. And your client didn't accept it. So then the question becomes, well, would she have accepted more? And that might be a negotiation strategy, offer more, go back and forth. And even if your client, through counsel, chooses not to engage in settlement discussions, doesn't the ultimate issue turn on, did your client cooperate with discovery requests? That would be a defense to bad faith, that there wasn't satisfactory cooperation, information was withheld, and so forth. So I'm sort of struggling with this idea that, at least under the law that applies to this case, that there's been a showing of necessity and appropriateness to get information. But neither party seemed to really get into this idea of, well, what defenses would there be regardless of any information that's disclosed in violation of attorney-client or work product?
right, and we tried to brief that. I'm sorry if we didn't do it well, but the substantial need to overcome work product, which is completely inapplicable to attorney-client. But does Progressive have a substantial need? And that also, is there any obligation on Ms. Kesler as a claimant to, quote, cooperatively compromise her policy limit and take less than she believes by her CRN's submission she's due? A claimant merely says to the carrier, I've been hurt, I have coverage, I am making a claim. The carrier then must investigate that claim. It must evaluate that claim, and it must pay that claim.
And there's a duty to cooperate.
And there's a duty to cooperate on the part of the insured, and can give rise, if you materially don't cooperate, to a prejudice forfeiture of coverage defense to a carrier. Okay, so which is a non-issue that was never asserted by Progressive. But yes, the tools in the toolbox that Progressive owns through its policy language include such things as an examination of person without a lawsuit, right? An examination under oath without a lawsuit. They have the discovery tools that parallel much of litigation tools to investigate and evaluate a claim. The issue in the court is simply on the merits, is simply this. Knowing that it could have paid under the Talat and Vest theories of what is a cure, right? Cure is payment. Okay, it's not an offer, it's not a negotiation, it's you pay a benefit that's due. Here it's a benefit. Vest and Talat say if the benefit is paid, you've cured. If you cure, there's no statutory bad faith case. That cause of action doesn't exist at all. If you don't cure, and you don't use that 60 days to say, maybe this is the claim we should have paid, and you choose to stand behind your non-payment decision, then you risk a jury will later find that that non-payment decision was, quote, bad faith in the sense all you had to do is write the check. And
That goes back to my question.
yes,
Which is, even when that notice is issued, if they don't want to accept it because they don't believe the value of the case warrants it, that becomes a defense to the bad faith claim.
that goes to what I would argue to be the sole issue that we try in this case. Should Progressive, acting fairly and honestly and with due regard and diligence and care, have determined to make a payment during the safe harbor of cure, thereby meeting its obligations under the policy as well as avoiding any bad faith remedy vesting? That is the core issue. And the Progressive is entitled to point out what it did have, and I'm entitled to point out what you should have had. And if there's non-cooperation, if there's purposefulness and avoidance, then certainly they can get into, they being Progressive, can get into, well, we didn't know and couldn't know, and therefore we shouldn't have paid. Those are all go to the central core issue of a UM bad faith case. Did the UM care do its job to investigate, evaluate, and pay? Did it attempt to get records that could not be gotten? Well, of course, that's a defense.
You still have here just over 8 minutes. Do you want to reserve any time for a vote?
I'm sorry if I didn't say I had 5 minutes. I apologize. I'm sure it's an omission. Thank you. So 8 minutes, meaning I have of the 20.
You have 3 minutes when you hit your 5.
I appreciate that clarity. So yes, that is the central issue. So if we look at what does Progressive need to know, what's the substantial need? It's not what's in the mind of the claimant or Ms. Caplett. It is what did we know and what should we know and what could we, with exercising diligence and care, know? And did we, with that knowledge, act fairly and honestly and make a fair payment? That's the UM case.
Progressive's main argument is lack of records, which can be a problem, but also a late undisclosed surgery. And they put in their appendix that she had testified she didn't want surgery. And she had surgery late in June or something like that, and then they tendered limits. Could they be deposed, Ms. Kesler, and say, why did you wait to have surgery?
Your Honor, I think this case gives this court, and I would submit claimants generally, the opportunity to provide overall guidance to what is the issue in a first party bad faith case and what's the relevant scope of discovery and information needed by an insurer. It certainly isn't to invade an attorney-client's communications with the claimant about anything that has to do with the claim. So now we go to the next layer, which is, well, what about the attorney's opinion work product or fact work product, or what is or isn't in the attorney's file? Let me lay that out in practical terms. If an attorney is going to express an opinion, and you could express it, I don't want to invite the argument, they could say, well, they've opened the door. I say that by letting Ms. Katchler testify to as much as she did about her opinion of the value of the case, perhaps that means that her work product is now discoverable, right? I didn't see that in the papers, but I'm going to be upfront with the court.
Well, there's a difference between fact work product and opinion work product. Once it got to her opinions in terms of the way she related and what opinions she related to Ms. Kesler, she invoked the privilege. But when it came down to her experience as a trial lawyer, as to how she evaluated the case, it seems to me that she was candid.
I don't think that anyone has accused Ms. Katchler of lack of candor. I think what we're trying to establish through this petition is the ground rules for trial judges who I argue this in front of. In fact, with the opposing counsel's firm, I was in front of Judge Barber yesterday on willingness to settle in a UM case is an issue. So I think that if willingness to settle is a non-issue, that takes care of the attorney-client invasion issue, right? Because there's nothing here about a willingness and, did you advise the client that she should settle and why didn't you take these other numbers? And none of that's relevant. On the issue of fact work product, it is certainly arguable that they had a substantial need to show that the attorney had information in her file or his file that was not shared. Not why wasn't it shared, the mental reasons for that, but just, hey, you had this record and you didn't give it to us. And that was material, right? And with that material, and then I argue, what you should have had that. If you didn't get a med auth, you should have gotten a med auth. You should have pursued the medical authorization. You never rely on a case law about, you can't just take the plaintiff's word for anything when you evaluate a claim. So, you go get your own records, and if you didn't get a med auth, you insist on it. And if the med auth doesn't come, you reserve your coverage rights. There's many tools and many ways this gets handled without invading an attorney's fact work product, and certainly the attorney's opinion work product.
Judge Sleep, give me just a moment. You're at the 5 minutes. We'll let Judge Sleep ask his question, and then you can respond to it briefly. And if you want to reserve the 5, you'll need to sit down after you answer that.
What's your response to Progressive's assertion that they're finding out that the Ruth firm contacted you during litigation is somehow discoverable?
That's just completely outside the scope of discovery, non-discoverable, and it's a quid pro quo for Genevieve Shaw.
Good morning. May it please the court. My name is Carlos Gomez and I represent Progressive. Your Honors, this court should deny the petition and affirm the trial court's discovery order because there is no departure from the essential requirements of the law, and neither do we believe that the plaintiff has established irreparable harm here. Since irreparable harm is a jurisdictional element, I think the court should probably analyze that
Well,
first.
just ask a question about that. I mean, if you're basically allowed to, to conduct a deposition and inquire into the attorney-client privilege, that's a pretty sacrosanct thing. So how would you elaborate on the lack of irreparable harm? Because that seems irreparably harmful to me.
Yeah, Your Honor, and I think the issue here is we're dealing with a very specific discovery order that posed very specific discovery or deposition questions to the attorney. Part of the argument with the trial court judge was that the questions that were posed to Mrs. Catledge, we don't agree that they were actually seeking attorney-client privilege communications. And the request for relief during the hearing was, we want to ask Ms. Catledge these specific questions. I don't agree that the trial court just wholeheartedly waived or issued some sort of blanket waiver or allowed Progressive to engage in any and all communications or ask questions about any and all communications related to attorney-client
You
privilege.
agree the trial court order doesn't give any narrowing of what can occur at the deposition, correct?
I do agree with that, Your Honor.
So isn't that problematic?
I think the trial court's order necessarily has to be limited to the specific relief and arguments that were present or presented to the trial court judge.
Does the record tell us who prepared this order for the court, or the court prepared on her own?
I think we prepared the order, counsel for plaintiff approved it, or executed it.
I'm not sure if it was you below, but counsel below for Progressive spent the bulk of their time talking about the work product paper discovery.
Yes, sir.
And then you transition, it's only a couple of pages. The same concepts, the concepts you argued about work to C4, which is undue hardship and everything else, which the Supreme Court made very crystal clear, doesn't apply to attorney-client privilege in generation. That's one. But you argued, or someone argued below, the same concepts as to work product in deposition. And you said, we were questioning her on the basis for their position that the claim was worth more than $200,000. We've already answered. And then we believe we are entitled to know why they thought that. The rule 1.280 clearly says you can't give the attorney's thoughts and conclusions and questions. So you argued, you tried to bootstrap 1.280 into the attorney-client privilege when you know full well the Supreme Court said no. The Supreme Court even says, even if that disclosure supports your defense, the attorney-client privilege prevents it, prohibits it. And so the court granted your motion for a second deposition, because you cite a federal case, Wilkins, some other case, written, that's the first deposition of the attorney. This is the second deposition of an attorney who told you, here's from A to Z how I evaluated the case. factually. But then you ask, was your client willing to take less? Well, how is a client to know that unless the attorney advises them? Tell me that.
Well, I think with regard to whether the client was willing to take less, Judge, I think that is a simple yes or no response.
But that's a conversation between Ms. Kessler and Ms. Catlidge, is it not?
Well, it would be if we asked her what the why and what those communications were.
Okay, so Mr. Lenigro was the attorney below?
I'm sorry?
Was Mr. Lenigro the attorney below in the Dion case?
Mrs. Catlidge was
He was the defense attorney.
the defense attorney. I'm not sure.
Okay, so let's just say it was Mr. Schmidt.
Yeah.
So based on your argument, we accept your argument, we deny this. Then Mr. Gunn's firm can go take the deposition of the defense attorney and ask him, how did you evaluate this case and what offers did you tell him to make? And what was the ultimate offer to make? And what did you tell them about how to handle this case? You agree?
If Mr. Gunn attempts to take the deposition of the underlying attorney, the defendant, yeah, I think that they are allowed to obtain that sort of information because there is, according to Allstate versus Ruiz, Your Honor. Well, if you're
Simply puts a work exception to the claims filed. The Supreme Court had the right Genovese to say, oh, wait a minute, attorney-client privilege still applies. Two different cases, two different issues.
sure, yeah. So let me clarify.
Based on Genovese, could they take the defense attorney's deposition and ask him, what occurred between you and the adjuster? What did you advise her to offer? What did y'all evaluate the case at?
No, based on Genovese, I don't think that they can ask those questions.
That's why are you?
And so going back to the specific questions that were asked of Mrs. Catlidge, those questions were 4 questions. During your handling of the claim, was Ms. Kessler willing to negotiate for less than the policy limits? Was Ms. Kessler?
Those two talking and having a private discussion because Ms. Kessler is not sophisticated in personal injury litigation. She has to rely on Ms. Catlidge to say this isn't enough because your injuries are X, Y, and Z. Plus, Ms. Catlidge was candid in her deposition and said, you guys undervalued this case because it's a significant injury. She's been through a lot.
Yeah, I think attorney-client privilege, because it is a strong privilege, Judge, it has to be interpreted narrowly. It is the privileged communications regarding the rendition of legal services or the rendition of legal advice. We're not asking Mrs. Catlidge to disclose those specific communications that she had with Mrs. Kessler. We're asking her a simple yes or no question. Was she willing to settle for less or no? Yes or no? Was Ms. Kessler ever willing to accept was Ms. Kessler willing to settle for the $200,000 policy limits? Yes or no? At what point was Ms. Kessler no longer willing to settle for the $200,000 policy limits? Give me a date. But we're not asking her, explain to me what communications you had with Ms. Kessler related to those decisions.
Well, the record's pretty clear that Ms. Kessler was willing to accept $200,000 in limits as of December 4th, 2018. And they never, ever wavered.
I understand that that would be the plaintiff's position, and which means,
the record shows.
well, the record,
You offered $43,000 3 times meds, and then you found some more records and you offered $75,000. But they stayed at $200,000.
the record shows that Mrs. Kessler filed a CRN, which she has to do in order to perfect a statutory cause of action for bad faith under 624155. I think that goes beyond the pale of establishing that she was willing to settle. I think there's a slight difference.
Because you think the case is worth less. Beyond the pale, the law is clear that a plaintiff or a claimant can file a CRN even before you determine liability and damages. They are not required by law to make any kind of counteroffer to you. They can file a CRN.
It would be no different, Judge, if even in a third-party context, the plaintiff sends a demand and says that I'm willing to sign a release on behalf of just to release the insured if you immediately tender the policy limits right now, but I'm not going to provide you the necessary medical records that you need to substantiate a tender of the full policy limits. I'm not.
That's a different issue. And that goes to the question of bad faith and whether you have a defense to bad faith. Right?
Well,
you're not entitled to say, or at least this case is addressing, you're not entitled to say, we have all the records, we don't think the case is worth 40,000. What do you think the case is worth? I mean, is that something that, is there any authority that says you can do that?
Well, Judge, I think it goes to the issue of willingness to settle, which Mr. Lee does not dispute that they have to establish.
To settle demonstrated by you make an offer and it's accepted or rejected. Maybe you make another offer and it's accepted or rejected. You might make 10 offers and they're either accepted, one of them is either accepted or rejected. And it seems to me if you're asking a plaintiff, an individual plaintiff, basically, what is your case worth? Doesn't that necessarily involve an evaluation by the attorney? That's why people go to lawyers?
Yes, I do agree with
You're
that.
not a lawyer, right?
Ms. Kessler is not aware.
So are you suggesting that any plaintiff has an obligation without the advice of counsel, without the assistance of counsel, without the input of counsel to know what their case is worth?
I think that I don't know about the specific, it depends on what the plaintiff would say. The plaintiff might say, well, I relied on my attorney, in which case then we would ask the attorney, okay, then what do you believe the case was worth?
Well, let's say you can take her deposition again. I'm talking about Mr. Catler's the attorney. Because you seem to argue here that if Mr. Kessler said, you know, I'm broke and I really need to take some kind of money, can you just try to get less? And Ms. Catlett says, you have a neck injury that may or may not need surgery. You have these issues, and based on my experience, you're going to have ongoing problems, and I would advise you against it. And if she accepts that advice, what you're saying here is that conversation is discovered.
No,
She relies on her attorney, well, even if she's willing to because of some personal reason, but her attorney who she's relying on says, I would advise against it because of my experience, your injuries, and what I've known in the past, and you're going to encounter, it's not enough. And she says, okay, I agree. You're saying that conversation is discoverable in a bad faith case.
Well, it really depends. I think with regard to the specific questions that were posed, I think we're entitled to attorney-client privilege.
So in that scenario, let's say she was willing, but the attorney told her not to based on her experience with injuries like this. Because she ultimately had a fusion of her neck, which is not a laminectomy, discectomy. This is a major deal. Okay? So what you're saying is even she was willing to take less than 200. And they had that conversation. And Ms. Catlett, based on her experience as an attorney, said advised against it, and she agreed and said, okay, I won't. That's discoverable.
I would argue yes, because it goes to the direct issue, the essential claim that the plaintiff has to establish, which is good himself.
Defense attorney for the UN carrier, Progressive says, you need to sell this thing for 200. The adjuster says no. Mr. Gunn able to take that deposition and ask about that conversation, is that discoverable?
Arguably. If our defense is we're placing the direct issue on our defense, saying that we couldn't have seen that case.
Defense attorney in this case, that's an exception under the law. If you're blaming defense attorney, then the attorney's line goes his way, but you're not in this case. So what I'm saying is that the defense attorney for Progressive told the adjuster, you better settle this case for 200 for policy limits. And she said, no, I'm not going. Is that discoverable in a deposition?
I don't think so, Judge.
Okay, then why is there?
Because I think it's the plaintiff who places it at issue, and she has the burden to prove.
What's at issue, and what the Supreme Court says is the focus on a bad faith case is on the conduct of the insurer. You misread Berry. Berry is a post-trial appeal of a denial of a motion for new trial. In Berry, the expert testified and the plaintiff did not object. The expert testified that they manufactured a bad faith case. The fourth DCA said there's no error. You invited the error because you didn't object. And then the fourth DCA reminded us that the focus is on the carrier, but the motives of the claimant and their attorney is relevant. That has nothing to do with the pretrial discovery deposition of the plaintiff's attorney.
Judge, the The case law also says that while the focus is on the insurance company or the conduct of the insurance company, the case law also says that the standard is the totality of the circumstances.
Right.
And so what the vast majority of the cases, granted they are in federal court because we have a lot of federal litigation on these issues, say that based on the totality of the circumstances, the conduct and the motives of the underlying claimant's attorney is relevant. And based on that, the insurance company has a substantial need to invade the work product material of the underlying attorney. In the same way that an insurance company has to disclose their claim file material, because it's virtually the only source of evidence that.
But that's different, because the case law talks about the insurance company has a duty to properly, fairly evaluate the case. And it can do that with records. Maybe it can't do it because there's an absence of records or there's a failure to cooperate by the plaintiff. But the plaintiff's evaluation of the case doesn't seem to me to make a big difference to the insurance company, except, well, maybe we can sell it for less than we think they really will take, and we can do better. Don't you avoid that by making offers in what you believe are reasonably defensible amounts to settle the case?
But with regard to that specific issue, Judge, I think it could go to the credibility of the plaintiff's attorney who's going to come in at trial and testify that Progressive should have tendered the full policy limits. And if we have evidence from her file suggesting that she didn't even think that her own claim was worth the $200,000 limits when she sent the CRN, then I think we're entitled to that discovery.
It's different motivations, one of which may be get the money as quick as possible, one of which may be changing motivation as to what settlement amounts if something happens. For example, she realizes she needs surgery. So the plaintiff's lawyer's evaluation and advice to the client seemed to me to fall squarely within the privilege and work product protections as to their own evaluation. I'm really struggling with this idea that we need to know if they would have accepted less, because if they might have accepted less at some point in time, then we didn't have to pay the full amount. And the reason I'm struggling with this so much is the amount might change as the case goes on. Once they do pre-suit negotiations and it fails, the case may have been worth $50,000 pre-suit. Now they got to get experts, they got to get records, they have to do things. So the number is shifting. A plaintiff, I don't think a plaintiff can make those kinds of decisions without the advice of counsel. That's where I'm struggling with this, because you haven't really addressed how's the plaintiff determine what a reasonable value of their case is.
Yeah, so I mean, there's two issues here, and perhaps we're maybe conflating between attorney-client privilege and work product. Our position with regard to the work product is that we are entitled to it, because in a bad faith action, there is a substantial need for us to assess the veracity of the plaintiff's claim and defend our position as an insurance company, which was that the claim was not worth the policy limits at the time that they made those demands. And perhaps even the plaintiff was preventing us from actually settling the claim because they failed to provide this necessary documentation.
You believe that the trial court was correct in doing the in-camera, and you may get that through that process, but you have to agree that Genovese clearly says that the undue hardship does not apply to attorney-client privilege information.
To attorney-client privilege, and I agree with that.
And even if it supports your defense, that's still not an exception to the attorney-client privilege under Genovese, correct?
Correct.
Okay.
Yeah.
So we're talking about the second deposition of an attorney.
Mhm.
No.
Okay, so establishing that with regard to the attorney-client privilege issue, Judge, again, we're talking about a very specific discovery order here. The document production hasn't been issued yet, and so I don't think that's right for the court's review at this point in time. The issue on appeal is the deposition testimony of Mrs. Catledge. The four questions that were posed, and I understand that Your Honor might disagree whether it necessarily requires the disclosure of attorney-client privilege, but when the plaintiff states that the issue could have settled, and that we fundamentally establish or conclusively establish that we are willing to settle by the filing of a CRN, then I think we're entitled to assess the veracity of that claim and ask them about that. When you're telling me that you were willing to settle by sending a CRN, and then we ask you, well, at what point were you not willing to settle? Attorney-client privilege.
You have an independent statutory duty to evaluate the case and determine what it's worth without taking a plaintiff's deposition. You have that independent duty. What you're saying is you could not do this without hearing from the plaintiff as to whether she would take less. It doesn't make sense.
The deposition of the attorney was taken in this bad faith case.
I understand.
Right. And so maybe let's.
And you asked her if she was willing to take less in the
Right.
UM case.
Correct.
Right. That's what I'm getting at.
Right. And so going to the actual facts at issue in this
But it
case.
goes back to your duty. You have an independent duty. You can't take a plaintiff's deposition and figure out what it's for. You have an independent duty to evaluate it and determine if benefits are owed or not.
I understand that, Judge, and nobody's disputing that. We understand that we have an independent duty.
That Bridget was unable to evaluate this UM without hearing from Ms. Kessler whether she was willing to take less.
No, we're saying that we are entitled to know whether Ms. Kessler was willing to take less and at what point was she no longer willing to settle for the $200,000 policy limits, because we are entitled to defend our position, which is that we were trying to get records from you. You weren't providing them.
Show me in it's just a cold record. Any indication that she was willing to take less, given the fact that they stayed at 200 since December of 2018, and they never wavered.
Well, the proposal for settlement is one example where she demanded less than the $200,000 policy limits. But I think probably more.
So
Correct. And so I think if the plaintiff was willing to take less than the $200,000 policy limits, that's a simple yes or no question. I'm not saying that we perhaps will get any smoking gun out of that. I just don't think that that's a privileged question or demanding necessarily privileged communication.
At the end of your time, so take about 30 seconds, wrap up. And then
Yes, Your Honor.
Question, brilliant.
Well, finish answering and then we'll start to go down.
Sure. So, Your Honors, just to wrap it up then, when it comes to work product privilege, Progressive is entitled to that material based on law. I don't think that the plaintiff has cited any case law or any specific established principle of law that the court has violated in this case. Genovese stands for the proposition that an attorney-client privilege cannot be invaded with regard to the attorney, but when the plaintiff places the specific issue at issue, I think at that point it's waived and they're using it as a sword and shield and we're entitled to that information. Unless the court has any other questions.
He's out of time and it'll take too long to ask it, too long for him to answer, but I appreciate it.
Thank you, Your Honor.
Judge Lee asked all my questions.
Okay. Appreciate it.
May it please court. The fundamental flaw of Progressive's argument about the could is that in a statutory first party bad faith, they pay the money and the claim is settled. They could. And if they pay it in 60 days, there's no bad faith on a CRN. And if the case progresses, Judge Silverman, to a point where, oh, now it's really clear, as often happens, they have the surgery. Oh, well, now we'll pay the money. Without a notice of insurer violation proximal to, right, that surgical recommendation, that then they still don't pay, they don't cure. I can't talk about, well, now you know she's going to have surgery and then you didn't pay either. I'm confined under the law to the notice that I have given that at the time of the notice and during the cure, this claim was worth $200,000 and you should pay it. It is because of the mechanism of the civil remedy notice defining the scope of could and should that could is established as a matter of law conclusively by the ability under vest and to lot for the carrier to write the appropriate fair value payment check. The case is over, the claim is over, and no bad faith remedy exists. All right. So it is for that reason that there's no willingness to settle in this case. But what about the legion of cases, including federal, which have applied willingness to settle concepts of discovery? They're third-party cases or they're misapplying appropriate analysis. A third-party claimant's willingness to settle. Even if I would have handed the check to the claimants, remember, not the insured, the claimant, the third party, they weren't going to give me that release that I was bound to get for you. And that's why there's an excess judgment. So they in a third party case must establish the stranger to the policy, the injured third party claimant, would have settled. And they could have gotten a release. That's what makes this statutory structure so important to the scope of discovery. That distinction that if you wrote the check and you made the payment, so lot and vest tell us this is over. And the failure to do that is at your risk, insurer, that later in time, a jury will find that when you were given notice and a 60-day chance to get out of jail for free, you should have written that check. But you made a claim decision, advisedly or ill-advisedly, not to do that. And you can explain to the bad faith juror why you shouldn't have made the payment. I didn't know about this. I didn't get this. At that time, she didn't have a surgical recommendation. At that time, her medical bills were only $43. Please explain away why your conduct during the civil remedy cure was not to make the payment. But the issue below, the scope of discovery defined by that relevance, is simply this. Should Progressive, during that 60-day cure period, made a claim payment in good faith? And if it did that, they win their case. If they didn't do that. So then we look at the scope of discovery. I believe it was Judge Sleet who brought up the point about the focus on an insurance bad faith case is on the insurance company, its actions and its inactions. What the claimant thought she would take, less than 200, if anything, whether Ms. Catledge was advising the client, hey, if they come up with 175, maybe you just get this over with because it's going to cost a lot of money to go to court. That is not relevant. It is not appropriate scope of discovery. We would therefore ask that the lower court be quashed.
Very good. Thank you both very much for argument. We appreciate it. The next case on the docket, those of you who are paying attention, Johnson versus Progress Residential, it was canceled. It's not